Welcome aboard. If you're here today, it's because we're going to talk a little bit about New Jersey workers' compensation, and specifically, we're going to talk about ethics. Now, before you turn off your computer and run away in disgust and say, Greg, ethics? Really? Give me a chance, because I think we have ethical duties, but so does the other side, and I like to talk about that in terms of how we move litigation forward and what we have to do from time to time to hold the other side to account. My job as a defense attorney is to ensure a fair playing field for my clients. My clients often feel like they are taken advantage of and don't get a fair shake in a New Jersey workers' comp court, and it's my job to make sure they do. And one of the ways I do that is by making sure that the rules of ethics are followed by all parties, and this includes opposing counsel in our cases. So just as a reminder, we start into this webinar today. This presentation is for instructional purposes only, and it is not legal advice as to any particular matter. Never follow any legal advice you found on the internet or in a webinar. That would be crazy to do. And of course, a presentation on ethics has to start with an ethical disclaimer. I'm also going to say that if you're here and you joined live, it's because you wanted to participate in this webinar. So please ask me questions. This is an opportunity to ask me questions about this or any other topic in New Jersey workers' compensation that is on your heart and that you want to ask me. I am very comfortable answering any question. I will go through my prepared remarks, and today we are going to cover ethics from A to Z, and then I will answer your questions in the order that they are presented. I will say your first name, and just so you know that I'm answering your question, I will then read your question for the whole audience so that everybody knows that I'm answering your question, and then I will dive into answering your questions. So let's start. Goals of this presentation are just to give a brief overview of what the ethical rules are, where they come from, which ones apply. I'm going to talk about the ethical rules that we have to hold our adversaries counsel to, as well as the ethical issues that crop up for us. And we do have some special ethical issues that crop up for us as respondents. So where do these rules come from? Well, there's a lot of sources of these rules. Many are contained in the rules of court. There are some administrative code provisions that have specific requirements for us as workers' comp attorneys. And then there are ethics opinions, which come from the New Jersey Supreme Court Advisory Committee on Professional Ethics. So for example, you can look through those opinions and get some advice in a general sense about questions that other attorneys or parties have brought to the New Jersey Court Advisory Committee. So that's very useful for us. So these are the sources of ethical authority for us to refer to. Now let's talk about ethical issues for petitioners' counsel. Generally speaking, let's talk about the ethical issues they have surrounding their representation. And remember, this is a jurisdiction in which a separate retainer is not necessarily required for a petitioner's attorney to be retained to represent someone in the workers' compensation case. The mere execution of a claim petition signed by the petitioner and submitted by their attorney can begin that representation. Now, I don't represent petitioners, but my good friend and the co-author of the book that I write for LexisNexis, which is the New Jersey handbook for them, does. And he says, Greg, it is still a best practice for there to be a letter executed between the parties so they understand what the fee structure is going to be and who's going to pay the fees. The second thing that comes into play with the representation aspects of petitioners' counsel's duty to their client is when they want to stop being their attorney. Termination in this jurisdiction can be affected by them substituting out, meaning someone else substitutes in as the formal attorney. Sometimes, though, the plaintiff's attorney and the plaintiff can't get along to such a degree that before they can even secure a new attorney, the old one says, I got to get out of this relationship. In that moment, they need the judge of compensation to approve their withdrawal because it will leave the petitioner to be pro se or on their own or without attorney. And that does require judges' approval. Judges do not like it when petitioners become pro se. Why not? Because now the judge has to deal with a litigant who's not versed in court procedures, doesn't know what they're doing, and generally speaking is going to make a mess. In fact, the case that I reported to you guys about a couple months ago, that went all the way to the appellate division, and we won and actually got the appellate division to craft a new standard for, or elucidate the standard, I should say, for scientific evidence in a New Jersey workers' compensation case. That matter involved a pro se claimant who really wore out the court with filing needless and unnecessary motions and documents and letters and attacks, and just everything became ad hominem. And that's really what the courts are trying to avoid, these, unprepared, ill-prepared people trying to represent themselves. So that does require a judicial approval. Now, the Petitioner's Counsel has a professional ethical duty to keep their client reasonably informed about the progress of their case. Means they have to explain options to their client. And the way I interpret this is that when I make a settlement offer to opposing counsel, they have an affirmative duty to bring that forward to their client and bring that settlement offer to them. And I'll remind them of this, because I always don't feel like when I make a settlement offer, I've actually had opposing counsel say things to me like, Greg, that offer is so ridiculous, it's so low, I'm not even going to bring it to my client. I'm like, let me remind you of RPC 1.1, which says you have a duty to bring this to your client and keep them reasonably informed of the progress of their case, right? So I will push them by reminding of their ethical obligations to do that. In this jurisdiction, it's okay for petitioner's attorney to have pre-litigation contact with adversaries. How does this typically happen? It happens when the notice to you as the employer about the workplace injury comes from petitioner's counsel. They send you a letter. Or they send you a letter asking for specific information about their client. They say, my client's bringing in a workers' comp claim against you. We need some wage verification, or I'd like their personnel file, or any of those things. And that's allowed in this jurisdiction. Just be mindful about that. I think that's a moment where you should not be responding on your own, and typically you should be lawyering up. Remember that the carrier stands in the shoes of the employer. And so it's important that there's a good communication between the employer and the insurance carrier. And the reason I say this is because savvy counsel will note that there is an imputation or understanding that if notice is given to one of those parties, the other party is deemed to have notice. So for example, if adverse counsel reaches out to the employer or the petitioner themselves, the injured worker themselves, tells the employer, I got injured at work and this is what happened, and that is not transmitted to the insurance carrier timely, the insurance carrier may not be able to raise the defense of lack of notice because notice was truly given to the employer. So information given to one of those two parties is deemed to have been received by the others. That's something to be mindful of when you're defending these cases. In addition, there is allowed contact with physicians by the petitioner's counsel. They are allowed to interact with and communicate with the treating physicians. That is acceptable in this jurisdiction. That is not true for our forensic experts. So when we hire an independent or impartial expert, then there is an expectation that the parties are not going to communicate with each other party's independent or impartial expert. The regular ethical concerns about conflicts of interest also exist in this jurisdiction. And to be fair, conflicts are relatively rare for petitioner's counsel. I have seen some cases in which they're trying to represent two employees both involved in the same accident. Even in those instances, they've been generally successful in being able to do it without a conflict. But we are observant about whether there is a potential for a conflict. And the last thing that I'm going to talk about that's purely in regards to petitioner's counsel, but also, of course, applies to us as responding counsel, is the necessity of candor towards the judge and adversaries. We do have a duty to tell the truth and be as forthcoming as possible. In general, this is an ethical standard that we find easy to uphold. However, we do need to hold the other side to this standard as well. And I should also remark that this is a very relaxed courthouse setting. New Jersey workers' compensation court procedures and the interaction between the parties is generally pretty genial and generally very civil. However, we have to make sure our clients do not get taken advantage of by this genial setting. And that means that bald assertions, mere allegations, statements made maybe in front of a judge, that are prejudicial or might bias the court. All of those things have to be policed by defense counsel and reacted to where they are inappropriate. All right, let's turn to our or my responsibilities as respondents counsel, because they actually exceed significantly what the petitioner's counsel is exposed to. Let's talk about first the interesting and unique relationship that I have and the place that I'm in a lot of my cases. Defense litigation, insurance defense litigation, I should say, is one of the very few and peculiar areas in law where I am representing two clients at the same time, right? The first client and the true master is the respondent employer, who we call the client, right? That's the insured employer in the context of an insurer contract. At the same time, I also serve a second master, the insurance carrier. And this is an interesting relationship because oftentimes my relationship with the insurance carrier is on a much longer term basis and certainly might have a longer term financial impact than my relationship with the individual insured employer, right? So if you think about the typical employer, and look, Lois Law Firm is one of them. I have about 130 employees. I'm not self-insured for workers' compensation. I go to the market every year and I buy the most cost-efficient insurance policy that covers my employees, right? As an employer, not only do I not have a really long-term relationship with my insurance carrier, but I also don't, necessarily expect them to have that. We understand it's a transactional relationship, and it's going to be based on the best rates that I can obtain, or maybe the best premium that I can obtain, or the most efficient, or easy to pay, or whatever those reasons are. And that's very transactional and short-lived. But me as a defense counsel, I have relationships with insurance carriers. I've defended some for 14, 15 years at this point in time. And so those are obviously very long relationships that have a lot of background to them. But still, even though I am defending this client, that I'm the insured client, or I'm sorry, the insurance carrier, I might have defended them for 15 years, and they might have only written a policy for 1 year for the insured, I actually owe the highest duty to the insured, right? Because they're the first master. And there's long holding case law that goes back on this in New Jersey. There's nothing to the contrary that's going to instruct you that the primary duty owed by the defense counsel is not to the insured. And when I started researching this, because I wanted to put some quotes into this, I was able to find cases back from the 50s, and that's really when these relationships started to get described in the law. So here's a quote, and again, this is gendered because this has come from the 1950s, so take that out. But when counsel, although paid by the casualty company, undertakes to represent the policyholder and files their notice of appearance, they owe to the client, the assured, an undeviating and single allegiance. The fealty embraces the requirement to produce in court all witnesses, fact and experts, who are available and necessary for the proper protection of the rights of the client. The canons of professional ethics make it pellucid that there are not two standards, one applying to counsel privately retained and the other to counsel paid for by an insurance carrier. In other words, even where the insurance carrier doesn't want to spend the money for us to properly and fully protect the rights of the client, both the duty to defend, which is incumbent upon the insurance carrier, and then my ethical duty require me to do that, right? So now as defense counsel, I can never be put in a position where I'm not bringing a full and complete defense. Even where my client says, I don't want to, I don't want to spend the money, it's not worth, I got to say, yes, you have to. And not only do you have to do it because you have a duty to defend, that's one of the two duties you have under your policy of insurance. The other one is the duty to indemnify. But I have an ethical duty to present and defend them fully. Okay, that makes sure that the employer is fully cared. Now, although they are the payer, the insurance company's right to control the defense is limited by their obligation to the insurer. That's their duty to defend them. Defense counsel has to exercise caution to make sure that we are keeping everyone in the communication loop. And I have to provide accurate counsel. This includes a duty of self-abnegation and loyalty owed to all clients. What does self-abnegation mean? It just simply means I have to put my client's interests above my own as a defense attorney. Interestingly, the workers' comp insurance carrier can settle claims without the consent of the insured, right? Unless that right is specifically reserved in the insurance contract. And in general, we're going to do that. There are certain insurance contracts which are going to say, and particularly the large deductible policies where there is some level or an attempt at some retention of that risk, you know, $500,000 deductible, $250,000 deductible, $1 million deductible cases, there might be some opportunity or a lot of opportunity there if it's all within their layer for the insured to control those settlements. But in general, for the average employer, the insurance carrier can settle claims without the permission or consent of the insured. And when they are settling those cases, though, the insurance carrier can't just settle them for expediency's sake. They have to try to get the best possible outcome, including the best possible outcome for its insured. And that might disregard its own interests because the interests of the insured come first. Now, if the impact this has, and the place I typically see the interaction of this is around litigation management guidelines. These are issued by insurance companies with really good ideas, and their ideas are to control costs and to improve efficiency, or to be really clear and upfront with defense counsel. Hey, here's what we expect you to do in our cases. Here's what we think the best standards are. Here's what we think best practices are. Hey, here's the bright lines that we don't want you crossing in this relationship. I've seen litigation management guidelines that say basic things like restating my ethical obligations. You know, if you have a conflict, here's what we do, right? So these are attempts to both define the relationship and the boundaries, and maybe be as efficient as possible. And I agree with those concepts. However, where litigation management guidelines create arbitrary limits on a defense counsel's ability to fully defend a case, well, then that has to be resolved and there has to be a bigger discussion. For example, I've seen attempts to limit how much defense attorneys can work for other unrelated clients, or how many hours they can work on a matter. Those types of things could interfere with our ethical duties, and no, we can't accept those. A bigger issue that I see in this jurisdiction, or in my practice, I should just say, in my practice, is demands for representation that exceed the workers' compensation contract. So what do I mean by that? Remember, what we do here is workers' compensation defense, right? I'm retained, typically, pursuant to that duty to defend that's found in a workers' compensation insurance policy. The relationship between the insurance carrier and their insured, the employer, is completely defined by the relationship that's in that contractual insurance policy. And so my duty and the things that I should be doing should not exceed the scope of the representation that's contained within that workers' comp insurance policy, right? I should be defending the workers' comp case, providing advice and counsel to the insured about the workers' compensation matter, but nothing else and nothing unrelated. So little questions creep in from insureds from time to time. Things about separations, terminations, firings, ADA accommodations, employment practices issues they might have, releases, resignations, things that fall outside of the control of the workers' compensation policy or outside the purview of the workers' compensation policy relationship are not appropriate things for me to be providing advice and guidance to clients that are referred to me through an insurance company. So if their question exceeds the bounds of the workers' compensation law, it's not covered by the insurance policy. Now, sometimes I have clients, or we have in the insured context, we have clients who say, Greg, we want to do a Section 20 lump sum dismissal of this New Jersey workers' compensation case, but I also, Greg, want to do a release and resignation. Okay, but you're insured, which means that the scope of my representation is limited by the scope of your workers' comp policy, and there is no workers' compensation policy in this jurisdiction that will cover releases and resignations. It's simply, separations are not something that will be covered by workers' compensation. So in that context, we would then do a separate release and a separate retainer with those clients, and then we would go and pursue that release and resignation with petitioner. That doesn't apply, of course, in the self-insured context. If it's all your money and you want us to do releases and resignations in New Jersey, we'll certainly go out and pursue those for you, okay? So again, this is one of those intersections between ethics and contractual law and the day-to-day litigation of these matters that we have to take into account when we're making sure we're providing full and complete representation to our clients. I have the same candor towards the tribunal requirements as does petitioner's counsel. I also have the same requirement that when I sign a pleading, right? When I file a motion with the court, I'm signing my name to a certification in support of that pleading. When I sign those, I am bound by what I'm signing, and we need to be very thoughtful about that. That sworn pleading is considered my representation before the court, and there has to be a good faith basis for the things I'm stating. And that's why you'll see so many times within our certifications that we file on your behalf, we say, based on knowledge, information, and belief, right? And then we'll make a fact and we will assert it. Where I file an incomplete answer, be careful where pleadings are relatively vague or evasive. The judge can shift attorney's fees in those circumstances. Again, it's relatively rare because, again, we can amend a pleading up and until the first day of testimony in a workers' compensation case in New Jersey, but be mindful about that. That's why we don't file vague and evasive pleadings. I also have an obligation to communicate with opposing counsel. I have an obligation to try to narrow the issues in dispute, and I have an obligation to avoid frivolous litigation. What does this mean to me? It means that I need to be in near constant contact with opposing counsel in my case. I don't just wait for a case to go to a pretrial conference before a judge to reach out to my opposing counsel the first time. I'm constantly reaching out to them. Now, I did have one client who said, Greg, I don't like it that you're constantly reaching out to opposing counsel and soliciting settlement demands. That looks weak to me. It looks like we're weak and we're trying to solicit demands. And I said, look, maybe I understand the perception that you could have, but really it's better to be asking them early and often, hey, are you ready to close this case? Can we close this case? What's your number? To get them thinking about it. And I always want to be reaching out to opposing counsel. I need to say, what is holding you up? Why don't you have your permanency report? Why can't we go before the judge? Because when their answers to me are, I'm doing it maybe someday, that's when I file my motions to dismiss for lack of prosecution. I make the argument, Judge, they don't have their permanency report. It's been 2 years. What are we waiting for, Your Honor? You have to dismiss this case, Judge. They're not prosecuting it actively, right? So that gives me the grounds to make those arguments I need to make. So our communication with opposing counsel is sincere and authentic and engendered to try to bring these cases to a resolution. All right, I'm about to move into the question phase. That closes up my presentation on this topic. I'm hoping there are some great questions for me to review, and I see that there are. All right, so first question I have is from Erica, who says, Greg, if a petitioner's attorney files a motion to be relieved and there's no sub being filed, should we confirm that there will be a motion filed formally withdrawing the claim petition? Okay, then the next question says, sorry, typos above. Petitioner's attorney files a motion to be relieved and there's no sub being filed. Should we confirm there will be a motion filed formally withdrawing the claim petition? I think it's the same thing twice. All right, no. So when the petitioner's attorney files a motion to be relieved as counsel and there's no superseding attorney identified as coming into the case, and there's no substitution filed of a new attorney coming into the case, the court should list that motion before the judge as a motion to be relieved so the judge can address it directly. It should be a trigger. And the judge should be saying, why isn't there counsel? Have you told them that they need to get new counsel? Can you stay in the case until they get new counsel? That's generally what to do. So I'm going to adjourn it a few cycles. Let's let them get a new attorney. And unless there's a conflict between the attorney, the judge will generally try to militate towards there being a continuity of counsel representing the petitioner. All right. So interesting question. I'm glad you brought it up. And I don't see any other questions, which is kind of making me sad. But hey, maybe it's summer vacation and everybody has other things to be doing that they'd rather be doing. I get it. It was a rainy weekend and it is a beautiful Monday. So get out there and have some fun. Okay. Before I move on, let me just remind everybody, there's other ways to learn here from LOIS Law Firm. Obviously, you're invested and you care about workers' compensation because, look, you came here on a summer Monday, and this is how you're spending your summer vacay. That's great. We have a newsletter you can sign up for on our website. We've got multiple podcasts that we publish during the month. And I always recommend everyone check out my partner Christian's podcast called Third Fridays. It's going to be released on this third Friday, which is July 19th, and you can check that out. All right, everybody, have a great rest of your day and a great summer. I'll see everyone in the first week in August. Bye.